what happens in instances where you have property owned by one company but managed by another?
Right. Good question. So, in almost all scenarios, the actual owner, the title owner of the property, is liable or can be liable. However, when you have a situation where you have we'll call it, the landlord owns the property, and then you have a tenant, okay, which is very commonly the case in a commercial business situation. The tenant can also be liable based on an agreement, a lease, a contract. Within that lease, like for example, let's look at a commercial lease, it will it will almost always designate certain responsibilities. So within that lease, it will either say tenant has the responsibility to maintain certain areas of the property. The tenant has the responsibility, for example, to if there's sidewalks, if there's a parking designated parking lot area or common areas, or even within their space, maintain this area. Or the lease could say that the owner, the landlord, has these responsibilities. So under the common law, which means like the case history, the law history of Pennsylvania, a property owner has responsibilities to the property that it owns. It can't always just designate those or absolve itself from liability through a contract, but the tenant then can also be responsible. So then what would happen practically is if someone were injured and there's the lawsuit against the two, landlord and tenant kind of have to fight amongst themselves to figure out who's responsible. And there could be language, indemnification language, so that if one was held liable, that they could actually recover from the other.